According to your complaint, each of you put in an initial investment of $2,500. The partnership didn't work out. You wanted your initial investment back of $2,500 and claim initially the defendant said she would give it back to you. The defendant does not deny these facts. These are stipulated facts. So far, is that correct? Could somebody answer me out loud?
Yes, ma'am.
Yes. Good. Ms. Woolsey's defense is that she initially agreed to give you back the $2,500, but after she went through the books and records, she found that because of what she perceived to be your actions, or the business's actions, she found that she was actually in the hole for over $6,000, so she determined at that point that you weren't getting your $2,500 back. Correct?
Correct. So
we don't have to go into all of the other stuff. What happened? Why didn't it work out? You said she was lazy. She says you're lazy. Somebody changed their baby's diaper on the table of the cafe during a lunch period. Who did that? That would be you.
No.
Anyway, that's what she's alleging. It just didn't work out, and it was nasty. So then it's your job, Ms. Woolsey, to show me how, during the period of time between which the joint venture was entered into and the time that she was leaving the joint venture and you agreed to give her the $2,500, during that period of time, the business lost money.
Well, basically, I was in charge of operations, which was handling the overall appearance of the cafe, the artist, everything involved as far as mood, people, customers. Dana was in charge of the financials.
So far, is that correct?
Yes, ma'am.
During what period of time we're talking about? Let me hear.
We started April 1st is when we joined into an agreement. 07.
Okay. What month and year did you say you wanted out?
It was around July of 2007.
And the business was operational as of what date?
April 1st.
Okay. So show me between April 1st of 07 and July of 07 what we're talking about, Ms. Woolsey.
Okay. She had been sporadically coming and going. When she did show up, she was always late. We had meetings with bankers. We had meetings with people.
Listen to me. I don't care about that. That's not the issue.
Okay.
The issue is, let me focus the issue for you. You each put in $2,500. It didn't work out between the two of you. She wanted her money, her initial investment. Quite frankly, at that point, you could have said to her, listen, you put in your investment, you want out, you walk away from the business with nothing.
I did.
Just a second. Could have said that, and we wouldn't have been here because she has no right to get her initial investment back for this sort of a business venture in a restaurant. They fail all the time. They lose money most of the time, especially at the beginning. She says, and you agreed to the stipulated facts that I laid out at the beginning of this case, which were that you agreed to get rid of her, to give her back her $2,500. Then you found out that the business financially was actually in a hole for $6,000. That's what you said in your answer. All I want you to do, you have to tell me she didn't show up, she missed business meetings, just show me that the business lost money. And you are responsible for more than her $2,500 during that period of time. I don't even care whose fault it is.
I have July 16th, a second notice that she had not paid.
May I see? Paid what?
It was our business license.
Okay, let's see. Second notice, not paid business license, which is how much?
$66, I believe it's highlighted.
All right, that's $66. Do we have something else?
Yes. We had entered into an agreement at the bank for a bank note. Well, when Dana disappeared, it incurred interest daily. The interest was $969.56.
Can I see it, please?
Your Honor, I have a letter from the Bank of Franklin County, which is the bank that she has that letter from, stating I don't owe them any money whatsoever. The LLC does. The company.
What difference does that make? It says interest to September 18th, $969.56. That's what it says. You may not. The LLC does. That's your business. That's the business that the two of you went into. What else?
Dana called, and this is right when she disappeared, and asked that I get the first quarterly done and meet her in the cafe. I was served papers that day by her saying she was removing herself.
Removing herself from the LLC?
Yes, ma'am.
Yes, and this is the accounting fees with all the other accounting fees I had done. She remained on the ownership until March of this year.
Because she refused to give me documents so that I could get off of the LLC.
True.
Well, why do you think, madam, that you're entitled to any money back?
Because I am no longer a member of the LLC.
Who cares?
I have a paper from her attorney stating she is willing and able to pay me the money.
Well, show me.
No.
Show me.
Nope.
I have one dated August 27th that says she's willing to buy me out for the $2,500. I have one dated September 5th. I accepted the $2,500 payment. And then I have one for September 28th. Ms. Woolsey is willing and able to pay me, Dana Bowers, the sum of $2,500 by and no earlier than April 2nd of 2008.
I'd like to see it, please. Where is the letter from your attorney accepting this?
It's the second one.
Okay, great. Okay, so there was an offer and an acceptance.
Yes, ma'am.
Absolutely.
Dana Bowers says former business partner Manuela Woolsey owes for the return of her investment in a cafe. Dana says the business lost money and she owes nothing.
All right. There was an offer by your attorney and an acceptance by her attorney. Ms. Mandel is willing to buy out Ms. Bowers' interest in the Artist Cafe for $2,500. That was on August 27th. On September 5th, this is from the law office, to resolve the issues, my client will accept the $2,500 payment from your client. That's an offer and an acceptance. That's a contract.
Ms. Dana Bowers was supposed to return many items, which I still have not received.
Like what?
Checkbooks.
Where are the checkbooks?
I have them with me, actually. And I told her I would...
Oh, that's the second thing that you were supposed to have returned September 5th.
I told her I would return those items once I received my money.
Well, your $2,500 payment is contingent upon you have no credit cards and no equipment. Is that correct?
Correct.
Have you signed the non-compete clause?
She never provided it.
Okay. Well, that's easy enough for you to draw up. Are you still involved with this cafe?
Yes, I am.
You running it on a full-time basis?
Yes, I am.
Any part of it, any day of the week running a profit?
No, not right this moment.
You think it will?
Yes, if
Think
we
the-
can have
Think the
no
business is good?
Mm-hmm.
Good.
I also asked for my attorney's fees to be paid
That's
for
denied.
within that.
Did you pay your attorney?
Yes, ma'am, I did.
Well, you should. You go into a business, you're lucky you're getting your money out. She's not making any money.
It's her fault.
Well, maybe. I don't know if it is or whether it isn't. All I can tell you is that, you know, when you go into a business, you need two people working really hard full-time. Anyway, judgment for the plaintiff contingent upon signing the non-compete clause and contingent upon the return within 2 days of all of the books, checkbooks, and records. And your $2,500 is going to be held until all of that is done. Thank you. That's all.
Thank you.
Parties are excused. You may step out.
And now the next case.